Hello, my name's Peter. I'm a solicitor practicing intellectual property law and lecturing and writing about it. This is a short presentation about the reform of UK trademark law which took place early in 2019. I've chosen to cover what I think are the important highlights, particularly for students, but if you want to know more, I'm going to do some more detailed presentations and I'll tell you in this channel where you can find them. The change comes about because there is a new European Union directive on trademark law. It's Directive 2015-2436, and it restates, amends and unfortunately renumbers the harmonised trademark law which we're familiar with from two previous directives. Although the first one never talked about harmonisation, it talked about approximation, as if there's very much difference. So many provisions in the directive remained unchanged, some were amended, some were new, and some, contrary to the whole idea of harmonising the law, were optional. Similar changes had already been made to the European Union Trademarks regulation. So as far as practitioners are concerned, these are not radical new departures. They're something we're already familiar with, coming into UK law a couple of years after they've found their way into the European Union regulation. All the changes are inspired by a 2011 study carried out by the Max Planck Institute, which is a useful and interesting but extremely long, and I have to say very badly written, or at least badly translated, badly put into English, document which at the time felt as if it had a certain sort of self-congratulatory feel to it. But there we are, that was then, this is now, and what I'm telling you about is what's found its way into UK law. Directives, of course, need to be implemented. The European Communities Act 1972 allows the responsible minister to make statutory instruments to implement directives, amongst other things. And therefore what we have is the directive, the new directive, coming into UK law through the Trademark Regulations 2018, statutory instrument number 825, if you really want to know that, which make amendments to the Trademarks Act 1994. That's the important thing. And the way to read the new law is not to read the regulations, but to read a consolidated version of the Trademarks Act. And conveniently, the Intellectual Property Office has produced its own unofficial consolidation of the Act, so that's probably the best place to go and find it. No doubt it'll be in the research databases like Westlaw and LexisNexis in due course, and on the legislation website, but that often takes quite a while. The government has deliberately chosen to keep the changes to the minimum, to do as little as necessary to implement the directive. It went through a consultation process, published a consultation on the 19th of February 2018. This was done by the Intellectual Property Office on behalf of the government, set out what it intended to do and gave people the opportunity to comment on it. It then published its conclusions from the consultation process along with a draft statutory instrument in June 2018. It received 10 responses to the consultation, which seems to me to display a remarkable lack of interest, or perhaps people just thought it was going to be extremely easy. What, I hear you say, has this got to do with Brexit? And the answer is nothing. Notwithstanding that it had to be brought into effect on the 14th of January 2019, just 70 odd days before the UK is due to leave. By the time you listen to this, goodness knows what might have happened. There was no getting away from the fact that the directive had to be implemented. The Intellectual Property Office in its consultation document does identify the advantages to businesses of keeping our trademark law aligned with EU trademark law. Perhaps I was reading it too literally, but I didn't discern a trace of irony in that. Clearly taking back control doesn't mean taking back control of trademark law, although I'm bound to say I think the Intellectual Property Office is right, and it makes a great deal of sense to make sure that our trademark law doesn't differ from that in the rest of the European Union, or indeed in the EU trademark system itself. If you're looking for information about the future treatment of EU trademarks in the UK, you've got to look elsewhere. That's not covered in the amendments to the Act. I've done another presentation on that topic, but it is a bit of a moving target at the moment. Whichever way you look at it, our starting point is Section 1, subsection 1a. So it's right at the start of the Act, the amended Act, and it's probably also the most important change. Before these amendments, a trademark had to be capable of graphical representation, and lecturers, textbook writers, and, in particular, examiners could make a great deal out of that. And in particular, we had the Court of Justice judgment in the Siegmann case, setting down criteria for working out whether a trademark had in fact properly been graphically represented, and basically telling us that if we want to register a smell trademark, it's pretty well impossible because you can't represent a smell graphically. And there are many other types of trademark where it's difficult as well. So that requirement has gone. It's no longer necessary for a trademark to be capable of graphical representation. What is necessary is that the representation of the trademark must enable the registrar and other competent authorities and the public to determine the clear and precise subject matter of the trademark and therefore the extent of protection. You can't tell whether you're in danger of infringing if you can't tell what the trademark is, and the registry has got to tell you that. So that's the new standard. The Trademarks Registry will be accepting representations of trademarks in new forms. They won't have to be graphical, they can be in MP3 files or MP4 files if they're sounds or movement of some sort. Smells and tastes are still going to be a problem, but less of a problem than formerly, and registering these exotic or non-traditional trademarks is no doubt going to be a great deal easier than it was before. Whether that's a good thing or not is something that perhaps you have to make your own mind up about. Whether it was ever a good thing for trademarks to move out of the area of purely graphical stuff, logos and words, is at least arguable. The next highlight from the Act that I want to talk about is the definition of an earlier trademark. In the previous version of the Act, Section 6, subsection 3, told us that the concept of an earlier trademark included not just a trademark that had been registered before, but also a trademark which had been registered and had expired less than a year earlier. And the purpose of this provision is to tell applicants for trademark registration what they need to look out for, what trademarks, what earlier rights might turn out to be relative grounds for refusal. So recently dead trademarks could count against an application if they were similar or identical and all the other criteria were met. Well, the new version of the directive doesn't allow this anymore, so Section 6, subsection 3 has had to go. What appears in its place is a bit more confusing. We can forget all about expired trademarks unless they get restored to the register. The legislation doesn't say anything about what you do with a restored trademark that's come back onto the register while an application was going through. So logically, the outcome of that is the trademark wasn't there to constitute relative grounds for refusal at the date on which the later application was filed. What the Act does do is, using language that it takes from the European Union Trademark Regulation, provides protection for someone who uses what would a trademark that would otherwise infringe the restored trademark, provided they use it in good faith. So if you register a trademark while the other guy's trademark is off the register because it's expired and it then gets restored, provided you acted in good faith, you're not going to infringe the restored trademark. And that trademark which wasn't restored at the time that you file your application won't be grounds for refusal of your application. Associated with this is a change to Rule 37.1, which deals with restoration, and that says that the registrar can restore the trademark to the register if the failure to renew was unintentional, which replaces the previous provision which said that he could do that if it was just to restore the trademark to the register. Next thing that the new Act deals with is the situation where an application to register a trademark is made in the name of an agent or representative of the trademark proprietor. It's a common problem when there's a falling out between agent and principal. And if they haven't already fallen out, then they're certainly going to fall out once the agent tries to register the trademark. Section 5, subsection 6 is a new provision which says that there are relative grounds for refusal where the agent or representative applies to register the proprietor's trademark, and it will be refused unless the representative is able to justify it. So this doesn't require the principal, the manufacturer or whoever it is that's appointed the agent, to have a registered trademark already. The whole point is there's a vacancy there on the register, and the agent or representative is trying to pinch the trademark themselves. The legislation doesn't make it entirely clear that whether the application has got to be for a trademark that's identical to the one used by the proprietor, who doesn't have a registration here. It doesn't actually say that the principal has got to oppose the application, but the whole drift of Section 5 is that there have got to be opposition proceedings, so I don't think it's going to be the case that the Trademark Office will refuse applications of their own volition ex officio. The final point, which I think is quite important though, is that it's not clear whether agent and representative includes distributor, and very often it can be a national distributor who steps in and tries to pinch the trademark when the relationship goes sour. I remember many years ago it happened with the Land Rover trademark in Brazil. The manufacturer didn't have a registration. When they fell out with their distributor, the distributor registered the trademark and they had to try and get it back. Exactly the sort of situation that this legislation should be aimed at, but whether it includes distributors or not is not clear. So creating a new relative ground for refusal of registration is one side of the solution to the problem, but it's also necessary to address the problem of the agent or representative using the principal's trademark. And what we had in the old legislation was Section 60, which implemented Article 6 septies of the Paris Convention and provided that the principal would be able to take action against their agent or representative using the trademark, notwithstanding the fact they didn't have a registration in the jurisdiction. Because it was designed to comply with the Paris Convention, it only covered principals who were based outside the UK, so the legislation now has to be extended to cover UK trademark proprietors, or whether the trademark is registered or not, as well as foreign ones. And this has meant that the provision needs to be moved around in the Act, because Section 60 is in the wrong part of the Act for something like this, and it's now Section 10b, so you need to know where to look for it. The remedy that Section 10b gives in this situation, where the agent or representative is using a trademark which they have registered but which conflicts with the principal's trademark, is a twofold remedy. First of all, well, in reverse order to what it says in the statute, they can get the register rectified. In other words, the registrar can simply change the registration to show the principal as the owner, not the agent or representative, whereas formerly under Section 60 it was necessary to go to court to force an assignment. And Section 10b also says that the principal can take steps to prevent the use of the trademark by the agent or representative. The directive used the word oppose, but the government didn't like to use that because it doesn't make it clear that the principal would be able to go to court and get an injunction. The use of the word prevent makes it much clearer that that's the way to proceed. The directive deals with another matter which is a bit related, where earlier trademark rights are protected abroad but not in the UK. Well, of course, generally speaking, the effect of a registered trademark is territorial, so if you've got a registration in another country it doesn't count for anything in the UK. But what what the directive is doing is creating relative grounds for opposing an application where the opponent has got a registered trademark elsewhere, and the application that's being opposed was made in bad faith. So bad faith is a crucial component of this. I'm mentioning this because it's quite an important provision in the directive, but it hasn't made any change to the Trademarks Act, and the reason for that is that the government took the view that what the Trademarks Act already said about dealing with bad faith applications was quite sufficient. It didn't need specific legislation to deal with this special case of bad faith. I'm not sure I'm entirely convinced, and I have never found it very easy to rely on the provisions about bad faith in the Trademarks Act. I can certainly see the logic, but in practice I'm not sure it's going to give trademark owners the protection that they really ought to have. Another new topic which the directive deals with for the first time is comparative advertising. Because it wasn't in the directive before, Section 10 subsection 6 of the Trademarks Act, as originally enacted, was homegrown. And if you ever studied it and studied the cases on it, you'll know that it was a bit of a dog's breakfast, bolting together two pieces of language which were in the directive for different reasons and trying to make from them a definition of when comparative advertising was basically fair and honest. The directive deals with the matter by referring to the Misleading Advertising Directive, which didn't exist when the Trademarks Act was originally enacted, so we couldn't have referred to it then. And the directive merely says that use contrary to the Misleading Advertising Directive amounts to an infringement if it is other than in accordance with honest business practices. So some of that wording that was in Section 10 subsection 6 is being carried forward, but in a rather more logical way. The Trademarks Act has been amended so that the wording used in the directive is copied over, except that it doesn't refer to the Misleading Advertising Directive, it refers to the Business Protection from Misleading Marketing Regulations 2008, which implement that directive in UK law, so that's really the proper way of doing it. The government decided that Section 10 subsection 6 served no further purpose, particularly because the Court of Justice has handed down a number of decisions which call the UK rules on comparative advertising into question, and it's repealed, which is a bit of a narrow view because Section 10 subsection 6 was never solely concerned with comparative advertising. It did cover other situations. The government seems to think that Section 11 subsection 2c, which is about using a trademark to indicate the intended purpose of goods, will suffice to fill the gap. I'm not entirely convinced, but let's see. The directive also deals for the first time with the reproduction of trademarks in dictionaries and encyclopedias and other works of reference. And for trademark owners this is important because including trademarks in dictionaries without acknowledging that they're trademarks can at least contribute to what's sometimes referred to as genericide, the process of a trademark becoming generic and therefore dying as a trademark or being killed as a trademark. So owners of certain trademarks, like Hoover for example, take great care to ensure that dictionaries don't misuse their names. This is transposed in Section 99A of the Trademarks Act, which allows the trademark owner to take steps to deal with this particular wrong. But the directive wasn't specific about what the trademark owner should be allowed to do, so the Act provides an enforcement mechanism. It says the court can order amendment or destruction of the dictionary or encyclopedia or whatever else it is if it's a printed work, and may order other remedies as the court thinks fit. So that's quite an important and novel new form of protection for trademark owners. Won't be important for all of them, but for those for whom it is important, it's very useful. The final aspect of these amendments that I want to talk about, there are plenty more, but I don't think they're sufficiently interesting, is the new non-use defence. Somebody threatened with trademark infringement proceedings was always able to defend themselves by counterclaiming for revocation of the trademark. In fact, it's misleading to call it a defence because it's a counterattack, and the idea of counterclaiming for revocation is to knock out the trademark altogether and then there's nothing there that you could infringe. So it's a kind of super defence. The main ground for revocation, of course, is 5 years non-use, without good reason. Since the Trademarks Act 1994 came into operation, the importance of non-use has been increased somewhat. So now, if a trademark that's been on the register for more than 5 years is used by an opponent as relative grounds for refusal of registration, the applicant whose trademark is being challenged, who's been opposed, is entitled to ask for proof of use of the trademark. And if the opponent can't prove that they've used it in the past 5 years, then their opposition fails. So it's consistent with that to amend the law about non-use to provide a defence in an infringement action, rather than obliging the alleged infringer to take steps to knock out the trademark by a counterclaim. What it means is that the infringer doesn't have to file a formal counterclaim. They can simply say that part of their defence, the claimant hasn't used the trademark for 5 years, and it makes it much simpler to mount a defence along those lines. Commentators suggest that this is likely to be very important and quite helpful when the UK leaves the European Union and over 1 million new UK trademarks are created automatically out of existing EU trademarks, which in a way brings me neatly back to where I started, because although it's not all about Brexit, in a way it is all about Brexit. Well, as I said, there's a lot more that I could have told you about the amendments to the Trademarks Act, but I'm sure you'd have got bored. Those are the really important ones as far as I can see, the ones that are most likely to feature in exams. You're allowed to take in your statute book, then the chances are you're not allowed to annotate it at all, and you're going to be in a bit of difficulty when the Trademarks Act that's in the book isn't the same as the Trademarks Act as it's operating. And for most syllabuses this will have come into operation before the cut-off point, when the state of the law is frozen for the purposes of your exam. So I think it's probably particularly important to try and memorise at least some of these changes, really important ones like the removal of the requirement for a trademark to be capable of graphical representation. That really seems to be the most important one of them all. Well, thank you very much for listening. I hope you found it useful, and I hope you'll find other talks that I've uploaded to this channel useful as well. Bye bye.